Okay, welcome back, folks. Now, for myself, for my clients, and any LLC that I was a part of, I'd want all four of these. I'm going to click all four of them. I believe in these. I believe this is very useful information that an investor will look at you and make a decision. Do I want to buy this company or not? Do I want to license these products or not? Are they a solvent company that is going to stay in business and that I can feel good about making an outside investment? Having all four of these uncompromisingly, unfailingly, never missing a deadline and paying an accountant the decent amount of money needed to properly frame these up, I would insist on that. And if I was an investor, I would absolutely insist on it. Otherwise, I won't invest in you because I don't understand where the money's really going. And I don't want to just take your verbal word for it. I want to see it. I want to see what you told the IRS. I want to see how you track all of it yourselves and how you've always been tracking it long before you ever met me. And if you can't provide that, I'm not comfortable investing in you. I like this discipline. I like the discipline of having an annual report. And by the way, a LLC is not required to have an annual report other than a very simple state filing that's only a page and a half long and gives almost no useful information. I would want this if I was a member, but it costs more and it eats up expenses out of the profits without question. This has its drawbacks. Dissolution. So important. I'm glad I started another section of the video because holy cow, is this the subject of a lot of litigation. Everyone's starry-eyed and all excited about how the company's going to do at the beginning. But when life gets in the way and poop happens and stuff gets real and things aren't turning out like we thought we were going to turn out, what do? My thought would be don't dissolve if only one member leaves. And regarding members to sell their shares to non-members, I would like to see that of a third option, yes with restrictions. So let's put yes. Yeah, it didn't open up any more boxes. I'd like to see a third box with restrictions, but because this creates an ASCII text file, Microsoft Word or whatever, you can add that in. Once this product, lawdepot.com, delivers you an actual working operating agreement, which it will do at the end, although we're several minutes away from that. This is a really good issue to contemplate. Hey, things go wrong. How will we dissolve it? What if supposing things go wrong, and it's not to be Cassandra or Mr. Negative or Miss Negative, when things go wrong, we've got to decide ahead of time what to do and not wait until that moment and then decide. That's very unfair, very poor planning. A good operating agreement will always discuss this. We hope it never happens. We hope dissolution comes because you get bought out by Clarium Capital for 1.5 billion. That would be a fine dissolution. Very few people get that. Very few people meet with Peter Thiel and get that kind of a buyout. Anyway, selling shares to non-members, this is tricky. Very difficult to explain, but basically the principle is that those non-members would arguably have equity, but they would have no management or voting authority. But the problem is you got to make sure to tell them in the sales contract and the sales agreement, make sure it very clearly spells out you're a non-member. And now we also get into some potential SEC kind of scrutiny. It would take too long to explain all this. Just say these are really good questions. Really important for you to think about and know about. Don't get ahead of yourself and try to anticipate every little thing. But the fact that this simple software for free, as I'm using it now, lawdepot.com, it eventually charges you something to give you the printed document. But at this point, the fact that it asks this question is a really good sign. And there are attorneys who will set up an operating agreement for you and not ask this. I don't like that. Having this document ahead of you completed, or at least to your best guess, before you walk into an attorney's office, that is the principle I'm trying to explain. That is what I advocate for. I wish all of my clients would do this. None of them ever have. All right. When either winding up or a member leaves, oh boy. See, it doesn't have the fourth box in proportion to other things that we will explain in the following chart. But you can put that in after. It's good for you to know about this. I want all my clients to understand this type of thing. Yeah, I talked about this earlier. Okay, yeah, I shouldn't. Okay, I preempted the software. Um, how to briefly explain this? I think it should only be one manager, but if you get enough diverse activity in the company where you need more than one people to do this, there are a number of good ways to set it up, of which this is a nice, uh, brief, quick summary. Again, nicely arranged, good looking software that is not cluttered and has relatively simple screen interface. These are tough concepts to briefly explain, but they're doing a pretty good job. Better than many law professors I've had who did an awful job at explaining this. Made it 10 times more confusing than it needed to be. That seems to be a law professor's job too. I'd have to throw in a big no here, but it depends what you mean by compete. That's a heavily litigated term and it would take too long to explain. We can see we've got different time limits here. This one, oh boy, you got to have it in there. Although if you left this out, then you would be relying on state law and legal doctrine and legal precedent regarding people taking a corporate opportunity doctrine. And that's usually pretty favorable to the original members. But you want to try to spell it out, sure, go ahead. The law is already on your side, even if you don't include this section. But sure, since they present it, it's good to talk about, good to think about. I've seen operating agreements that didn't discuss any of this, and they held up very well and were perfectly reasonable. That's a nice question. Rather than read these to you, I'm going to leave it to say there should be several others in this list too, to do with the patents, to do with the trademarks, to do with other intangible assets, the things that I do as an intellectual property attorney, but you can put those in after. The fact that they're not in this particular Law Depot software is because they're kind of rare and they don't come up as often. They come up more for me in my particular practice area. But for a lot of LLC operating agreements, it never comes up. Still, I would modify this. This is a nice interface. And also the question marks and the question boxes and this material here is laid out in a non-legalese, relatively cleanly stated English that's understandable. There are some legal terms in here, but they do the best they can to present them in a manageable way. It would take forever to try to fill in all the possible things that would get put in here. Um, I'm not going to list any here. See, that's a nice one. I used $10,000 a minute ago, but $5,000 is a good number. I'd rather, I'm going to not list anything here. Oh, no, I'll put something just so that we can have it. But it would take so long. And see, here's an option to add even more. This video would be impossible to watch if we explored all of these in detail. Just suffice to say, it's good that they put the person on alert that such things exist, and it's best to address them right at the beginning. I'm going to use today. We're going to pass on witnesses at this time. This is a great product. I just hope you folks got a lot out of this video. I have no connection to lawdepot.com. They've never heard of me, but that sequence of questions of setting up an operating agreement and giving you the example of how it looks right here, um, the numeric formatting, the simple, easy sequencing and layout without a lot of excessive subheadings and Roman numerals and lowercase Roman numerals and lowercase letters and uppercase letters. Many operating agreements go frilly and all out on all kinds of tabular columnization tabs, lowercase letters, uppercase letters, Roman numerals, regular numerals. It's too hard to read and it's unnecessary. Look at this. We've got a couple of letters and then we go straight to numbering with some nice, easy to understand, underlined, bold headings. And now here's a nice chart laid out nicely. Now you can't copy from here and then paste it into a document, and you should pay these people. I only wanted to let you know how it works and how outstanding of a process this is. The discipline of going through this for my clients, I would give anything for several of my clients to have done this before they got themselves in a colossal mess. And the fact that this lays it out in an easy to understand screen interface, can't beat it. I hope you enjoyed this series of videos. There are more operating agreements and more information on my website, tannerpatent.com/operating agreements. I consider this a really important area, really neglected by my clients and by a lot of people. This video is to help educate you and show you what you should be thinking about before you walk into an attorney's office and start getting people to sign operating agreements. You can do your own, but it's probably not a bad idea to have an attorney look at it. But it'll certainly cost less if you have carefully researched and understood and grasped and digested these questions that this particular piece of software from lawdepot.com asks you. I wish my clients would have asked. There's a couple more questions in here that I wish the thing had, and they have to do with intellectual property. I can tell I'm already losing most of my audience. Hope this was of some help to you, and I hope your business goes well. Thanks for watching. Let me know any other topics you want me to discuss. This YouTube channel is to help you. This is for information. I want to hear from you, and I want to know what things are on your mind.